We will start with AG number 1, Attorney Grievance Commission versus Asher Newton Weinberg. Mr. Kramer.
Good morning, Mr. Chief Justice, and may it please the Court. This case challenges this Court to protect speech that it may even find offensive, and to exercise judicial restraint when asked to punish judicial critics. This case does not merit punishment for two key reasons. First, the petitioner failed to produce clear, convincing, and compelling evidence to sanction speech. And second, because the respondent provided a diligent defense to his client without violating court orders or rules, in particular, the rules of professional conduct. This is a case in which my client was brutally honest. I guess the emphasis would have to be on the word brutally. But the problem here is that the plaintiff or the petitioner had the burden of proving that he acted with knowledge of the falsity of his statements or reckless disregard for the truth. It was the petitioner's burden. I don't believe the lower court understood that, because if you look at the lower court's opinion, pages 17 and 21, Judge Dumais complained that Mr. Weinberg offered no proof to support his allegations, that he failed to provide any competent evidence, and even questioned respondent's argument that it is the petitioner, bar counsel, that had that burden. Instead of looking to the truth or any merit underlying what he had said, she paid attention to the tone of what he had said and presumed that what he had said was reckless. Judge Dumais refused to examine the truth. The truth lies in the merits of the ruling that he was criticizing. But Judge Dumais felt that that was, quote, not before the court. It very definitely was and is before this court.
Mr. Kramer, would you put bar counsel to the task of proving that the judges that he accused of kidnapping are not kidnappers? And if so, how would bar counsel go about proving that those judges haven't kidnapped anybody?
I think we see from the Yagman case, Ninth Circuit case that I cited in our supplemental exception, that that type of allegation, although it seems factual, really amounts to rhetorical hyperbole. That no reasonable person, and actually Judge Dumais found this, that no reasonable lawyer would believe that she was actually complicit in kidnapping.
It's not a defamation issue. It's a rules of professional conduct issue.
It's a First Amendment issue. And under the First Amendment, we protect provocative speech, vigorous epithets, nasty name-calling, even profanity. And in order to sanction that type of speech, to overcome the First Amendment protection, one needs to show more than it's offensive, it's nasty. You need to show that it actually offers a real effort to accuse someone of crime. That's why in Yagman...
Kidnapping is a crime.
Kidnapping is a crime. Blackmail is a crime. Many of the things that Mr. Yagman accused a federal judge of were crimes. But the question is not whether this conclusory, hyperbolic statement is technically referring to a crime, but rather in the context of discourse, was it there to punctuate? And that's essentially what we have here. I don't believe anyone would have taken what Mr. Weinberg said to really accuse this judge of kidnapping his client. What he was making a point of is that by virtue of derailing the defense on the morning of trial, where he was poised for an acquittal, this lady had to be locked up again, placed in detention again. That's what he was getting at. And he has a right to get it at that way. Now, will I tell you, was it reckless, his choice of words? Yes. But that's not the recklessness we're talking about. What the petitioner has to prove is a reckless disregard for truth or falsity by actually, truly accusing someone of a crime. In Yagman, for example, Mr. Yagman claimed that the federal judge was drunk on the bench.
Didn't he say it repeatedly? On more than one occasion, didn't he accuse the judge of kidnapping?
He did in a motion for recusal, which I should say is absolutely privileged under this court's precedent in Norman.
It's privileged to a defamation claim.
It's a privilege to say anything that is relevant to the proceedings, as Norman v. Barrison held in 2011.
He can't be held civilly liable for that.
Well,
That's not what we're here on.
There's an absolute privilege for statements you make.
Privilege against what?
Privilege, certainly one is defamation, that's true. But the rationale in Norman, this court held, it's important that litigants be able to freely speak their mind, to make statements without fear of repercussions. This is clearly a repercussion. And I believe in the context of a hearing where he's making a motion to recuse, she said, what are your grounds? She didn't like the answer. But frankly, the answer, for the most part, was true and correct. Because the reality is that what the judge did in that case on the morning of trial was to totally trample and disregard the Sixth Amendment rights of Mr. Weinberg's client. What was done there, although Judge Dumais did not believe it was truly before the court, if she had looked at the transcript, I got to tell you, when this case first came to me, I'll share with you that I read some of these epithets, and I thought, I don't know if I should take this case. And I wasn't going to take this case until I read the transcript of the hearing before Judge Alban, because that was really outrageous. What Judge Alban did, talk about reckless disregard, was recklessly disregard this court's own case law. This court said that the judge has to make evidence-based findings that, one, the individual, the attorney, is likely to be a necessary witness, and second, to consider whether there would be any substantial hardship upon the defendant. She did neither of those things. In fact, she said, oh, that's being a prosecutor. I'm not a prosecutor. That's not my job. That's not my job. Well, it was her job. And in fact, there was no evidence that Mr. Weinberg would be a necessary or even a likely witness on behalf of the state. When asked about...
Mr. Kramer.
Yes.
What about the flyers that were gratuitously sent to attorneys where there could have been no litigation purpose or argument that these statements were not reckless because they weren't aimed at the purposes that you were just talking about for recusal or demonstrating bias?
Right. Well, fortunately for me in this argument, it was never disseminated to the public. It was sent to Judge Clavens, and it was kept within an insular group of attorneys and judges. So it was actually not widely disseminated. Although Mr. Weinberg thought about it, he obviously thought better of it because he never actually followed through.
But the group of attorneys weren't part of the litigation, correct?
That's correct. They were a private listserv of Maryland Defense Counsel. And the problem with peering into that and sanctioning speech there is that lawyers need to be able to freely talk amongst themselves, share ideas, share opinions on judges, scouting reports. You don't want to break that veil, because if you do, you'll be making every attorney within the listserv a potential Gestapo agent for this court. You don't want that. Lawyers have to be able to speak freely and candidly about judges. I don't like Judge Kramer. He never pays any attention to the law. He's horrible. Perhaps that's why there isn't any Judge Kramer. But the bottom line is that you need to be able to do that. We don't want to chill speech. And frankly, if you had this case and were stepping into Mr. Weinberg's shoes, knowing you had a case of mistaken identity. I mean, this case was primed for acquittal on the morning of trial. And on the morning of trial, there's a motion in limine that seeks no greater relief than Mr. Weinberg already agreed to. And suddenly, your client is locked up for the weekend on a day when she should have been set free. And the judge did step into the shoes of the prosecutor. The prosecutor didn't even ask to disqualify Mr. Weinberg. The judge said, well, is what you want, you're asked to get rid of Mr. Weinberg? Oh, yeah. And rather than following this court's law, making evidence-based findings, the judge said, well, the totality of the circumstances, we're going to have a mistrial. You made yourself a factor in the case. You know what? Mr. Weinberg was a factor in the case because he did his job.
Well, Mr. Kramer, let's assume for the moment we agree with you that it was error for Judge Alban to disqualify Mr. Weinberg. How does that, I mean, we know that circuit court judges, like judges here, are human and make mistakes all the time. How does that translate to legitimately saying that Judge Alban lied and was corrupt or whatever else he was saying about her? I mean, he had time to cool off. He may have been very frustrated that day with the ruling. But why is it not a violation of the rules of professional conduct to say that a judge lied when there's no real basis to say that she intentionally lied about anything?
First, this was not a judicial error. This was judicial malpractice. This was judicial malfeasance. This was a willful disregard of this court's law and of the constitutional rights of his client. And when Judge Alban had the opportunity to cool off and received 2 motions for reconsideration that quoted and cited this court's law, she willfully disregarded it. That's not error. That's stepping into the shoes of the prosecutor. That's exactly what she did. And when it comes to lying, as we see in Yagman, as we've seen in many other cases, we often talk about intellectual dishonesty. Do I believe it would have been better to say that she was not intellectually honest with her ruling? Absolutely. Would it have been better if he said she made a gross error in judgment? Absolutely. I probably wouldn't be standing here if that were his choice of words. But we don't punish the choice of words simply because they'd be offensive. And I think that's really the key. And it's under a rule which, quite frankly, punishes disparaging comments about judges, but comments that we as lawyers are encouraged to defend judges. It's a content-based restriction. Imagine that we replaced the word judges with the word governor, legislator, Congress, president. We wouldn't tolerate that under the First Amendment. Why do we do so here? And I recognize this court probably doesn't want to go as far as to address that issue. I don't believe it needs to, because I don't believe that there was actual malice in this case.
Can talk to us for a minute about the candor to the court issues. Your client made filings stating that the witness with 100% certainty was going to say that his client was not the person who did this. And it seems like there's no basis for that. Certainly not anything that he was told by the victim. How is that not a violation?
Well, he never got the chance to put Ms. Hirsch under oath.
But he had talked to her, and she did not say those things.
Well,
That's not a dispute,
obviously,
right?
there was a factual dispute, and the factual dispute was resolved against us. I grant you that. I think that he may have overpromised or perhaps been overzealous in his argument, but he never actually, if you look closely at those motions, he never actually quotes her as saying absolutely or 100%.
He gave the clear impression that that was, not just impression, he said she was going to say that. He didn't put it in quotes, but how does that matter?
Well, I think he had every reason to be very confident about what she would wind up saying under oath. I think that if you were to play it out as defense counsel, Your Honor, what you would probably do is have Megan and Ms. Hirsch stand next to each other, show the difference in height is nothing close. There are many things she said that were unequivocal, that this person was more than a head taller than her, certainly not the height difference between Megan and the victim, that the victim was, or the robber was closer to the 5'8" height of Mr. Weinberg than to herself, that the person had a thicker build, broader shoulders, olive-toned skin, and yet what was the most critical feature that stood out for Ms. Hirsch when she met Ms. Lemons? That she had light crystal blue eyes. Olive skin and light crystal blue eyes do not go hand in hand.
We understand there are differences here in the description and Ms. Lemon's appearance, but the bottom line is, as the Chief Judge was asking, Ms. Hirsch didn't tell your client those things and failed to authorize the representations that he made to the court.
Well, he testified otherwise. I would also say that there was a 3-minute conversation the night before he filed the first of those motions. I don't know why a lawyer would continuously ask the witness about what he would be able to say if he totally intended to disregard what she was able to say. I think there's ample evidence that...
He was trying to get her to say that it wasn't the same person. That's why he kept going back to her.
If he was simply going to misrepresent to the court, he wouldn't have to ask the question in the first place. He would just simply make the misrepresentation.
Well, he asked her for permission from her he asked her to authorize him to make that representation, and she never authorized him.
The night before the very first motion, that is on the night of June 17, 2020, they did speak for a few minutes. Now, Ms. Hirsch denies that there was as unequivocal a conversation. But I think it's telling that the very next day he does go ahead and file the motion at that point. The other thing that we have to keep in mind is that when you talk about potential witness tampering, which might have been suggested in the underlying criminal case, there's more than ample evidence that it was the prosecutor that did the witness tampering, telling Ms. Hirsch, well, you know, all these other witnesses have positively identified Megan Lemons, and you may not be the best witness because you only saw her for a brief period of time and you were under stress and duress.
I'm not sure how that is relevant here to what's going on today with you and your client. So I'm going to ask if before your time runs out, you want to address any potential sanction, or if you want to wait for your rebuttal.
I'll save that for rebuttal. But I would say that this was not a situation in which my client, contrary to the allegations of the petition, violated any court orders in arranging a meeting between Ms. Lemons and Ms. Hirsch. There was no extant, no contact order. These were special conditions that were contained in the commitment orders, but not in the release for commitment. It may well be that Judge Thompson should have repeated them, but he did not. The fact is the only pending order permitted legal appointments. And what would be a more important legal appointment than this one in a case of mistaken identity? Additionally, I think that the meeting was critical because the prosecution wasn't investigating the identity. They simply took the words off of a low-resolution still of a couple of witnesses who really couldn't even say. Their main witness was only 80% sure, wouldn't commit to it, and then disappeared. They didn't have any evidence when this entire case was derailed. Under these circumstances, I certainly do not believe that Mr. Weinberg should have taken this injustice on behalf of his client with silence. He took it to heart, literally and figuratively, and I believe that his taking the risk in speaking out against it was entirely appropriate, even if the precise words that he used were not. Thank you.
Okay, thank you, Mr. Kramer. You'll have a little bit under 10 minutes for rebuttal. Ms. Robier.
May it please the Court, Kelly Robier, along with Acting Bar Counsel Aaron Risch, on behalf of petitioner. No one disputes that Asher Weinberg is a zealous advocate for his clients. Zealous advocacy that crosses the line and violates the rules of professional conduct is inappropriate. It's expected and encouraged that advocates advance their clients' interests, particularly in criminal defense matters. But this case is an example of an attorney who stepped outside the bounds of fair play in advocating for his client. The rules of professional conduct dictate that in the course of representing a client, you cannot make knowing and intentional misrepresentations to the court. You cannot make statements with reckless disregard as to their truth or falsity about judges when you get an adverse ruling. And you cannot knowingly assist a client in violating a court order. Attorneys have obligations not just to their clients, but to the judicial system as a whole. In attorney grievance matters, hearing judges are tasked with assessing credibility and resolving any such disputes. Credibility determinations were central to the hearing judge's findings of fact in this case, and the respondent's exceptions hinge on this court overturning Judge Dumay's sound credibility determinations. The hearing judge correctly found that the respondent violated Rule 3.3a when he knowingly and intentionally misrepresented in two separate court filings that the victim would testify that she is 100% positive and absolutely certain that the defendant was not the perpetrator of the robbery. The trial judge heard the testimony of both the victim and the respondent, who offered differing evidence about what happened at that June 5th in-person meeting and then on that subsequent June 7th phone call between the respondent and the victim. The respondent testified that the victim told him that the defendant was not the robber. The victim testified that she never gave the respondent a definitive answer about whether the defendant was the robber. She simply wasn't sure. Judge Dumay resolved that credibility dispute in favor of the victim and found the respondent's testimony not credible. Notwithstanding that the victim never asserted that she would testify at trial, that she was absolutely certain that the defendant was not the robber, the respondent knowingly and intentionally misrepresented to the court the exact opposite. The respondent did not make a general proffer in his findings. In his filings, he specifically represented to the court that he spoke to the victim and that she will testify that the defendant was not the perpetrator. Unlike the victim, the respondent used unambiguous and decisive language. As this court opined in Attorney Grievance v. Steinhorn, courts have the right to rely upon an attorney to assist in ascertaining the truth of the case before it. As evidenced by the record, the court could not rely on the respondent's statements because they simply weren't true. As to the statements made with reckless disregard as to their truth or falsity, the hearing judge correctly found that the respondent violated Rule 8.2a on 3 separate occasions, namely the respondent's statements on the record before Judge Albin in that unrelated matter, his email to Administrative Judge Clavens that repeated those allegations, and the publicly disseminated flyer that directed users to a public Change.org petition for the recall of Judge Albin. The hearing judge correctly determined that the respondent's statements were not opinions and that they were made with reckless disregard as to their truth or falsity, and that those statements ultimately impugned the integrity of the 3 judges. Again, credibility determinations were essential in Judge Dumay's findings. She repeatedly found the respondent not credible. The respondent tossed out blame, and the hearing judge found that his attempts to explain his statements concerning the judges were not based on fact. The trial judge heard and rejected the respondent's attempts to justify his statements. Because there was no demonstrable basis for the respondent's statements, each of those statements constituted a gross departure from that of a reasonable attorney.
Ms. Robier,
Yes.
it's been suggested that the court should draw some type of a distinction between statements made in court where a ruling on behalf of a client is being sought with respect to recusal or even otherwise. Do you agree with that suggestion, that being overzealous or offering an opinion type of argument somehow takes us out of 8.2 in the circumstance where it's made seeking a judicial ruling?
In the facts we have before us, I don't believe, and the hearing judge found, that the statements were not those of opinion. They were statements of fact that were made as factual assertions in order for Judge Alvin to recuse herself. These statements were not those of opinion, and as this court said in Attorney Grievance versus Gansler, attorney speech both inside and outside the courtroom can be curtailed to a greater degree.
Assuming that they were pure statements of fact, and wrong statements of fact, but they're made in court by a lawyer who's seeking a ruling, do you still think that would come under 8.2, or is there any type of leeway that the court should consider, perhaps considering the goal of attorneys to adequately or zealously represent clients?
Attorneys absolutely can zealously represent their clients within the bounds of the rules of professional conduct. So when an attorney makes a statement that is not true and that they know is not true and that an objective attorney would not make, and that ultimately impugns the integrity, no, I don't believe there should be such a carve-out for those statements, even when they're made.
So this is different than a lawyer who's just wrong about the facts, arguing this is the knowing element that you're aiming.
Correct. And I think that that's borne out in this court's case law regarding 8.2 in Frost and Stanalonis and DeMayo. The respondent's overly zealous advocacy knew no bounds and went up to and included assisting a client in violating a court order. The question of knowledge and the question of intent were issues of credibility to be decided by the hearing judge. Judge Dumais heard the respondent's inconsistent and ever-evolving explanations that the order for home detention by Judge Thompson superseded the prior orders, and that the respondent was just simply unaware of the no-contact order until it was brought up by Judge Crooks at the July 28th hearing after the in-person meeting.
Just as a matter of law, when Judge Thompson didn't include a no-contact provision in his new order, is it your view that the no-contact directives from the prior orders were still in effect?
Yes, Judge Thompson did not, on the record or in any written order, strike or alter the no-contact provision. So it's Bar Counsel's understanding that those provisions would still be in place at the time the respondent arranged the hearing.
Couldn't a reasonable attorney, in looking at the form that Judge Thompson filled out, seeing that that specific box is not checked off, couldn't a reasonable attorney within that attorney's duty of zealous advocacy reasonably reach the conclusion in good faith that it was not still in effect?
So that's not the situation we have here, as Judge Dumais found that the respondent knew that the no-contact order was in place. The respondent testified to his extensive experience handling criminal matters. The assistant state's attorney took the stand and testified that it's common for these provisions to be in place. And so certainly under different facts, that might be the outcome. But what we have here is a credibility determination made by Judge Dumais, who explicitly found that the respondent knew about the no-contact order at the time he arranged the meeting.
Well, she said he knew or should have known. And 1.2D requires that counsel know something to be criminal or fraudulent. So it seems like her conclusions are inconsistent with the rule, especially when you take the fact that Mr. Weinberg is out there telling everyone that he's going to go meet with them, and he's not keeping this a secret what he intends to do. So how is that a credibility determination given the findings she made on that one particular conclusion?
So I'll start with the judge's findings on 1.2D. So in the findings of fact section, Judge Dumais does say that the respondent knew or should have known. In the conclusions of law section under Rule 1.2d, she says that the respondent knew, and further, in the aggravating factors, she finds that the respondent offered false testimony during the disciplinary proceeding when he testified that he did not know that the no contact order was in place. So I think that
What facts support her conclusion that he knew in the record?
I think it was a credibility determination that she made when the respondent was testifying, because he was offering these inconsistent explanations that were incongruent with each other. And so he couldn't stick to one story. So that, plus his extensive experience handling criminal matters, in which criminal defense attorneys know, not to arrange meetings between victims and defendants of violent crimes.
Can we back up for a second? Because he knew or should have known blank, and the blank is that there was a no contact order. So you're assuming that there was, in fact, as a legal, ironclad, undisputed matter, a no contact order in place. Is there a rule, statute, or case that says that the prior commitment orders, no contact provisions, are still in place even when that same box is not checked off in the subsequent order that says she can be released to home detention? Is there a case or rule or anything that says that?
Candidly, I was not able to find a case that either says one way or another about that issue.
If there's nothing that actually establishes that as a baseline underlying fact, how logically could it be found that he knew that to be the case?
Well, I think you have to look back to the underlying State versus Lemons case, in which Judge Crooks found that the no contact order was in place. Each successive judge in that case found that the no contact order was in place. Judge Dumais found that the no contact order was in place. And so that was the underpinning for that finding.
But was there any such finding before he made contact, before he arranged that meeting?
No, it's not my understanding that there was a hearing before he made the hearing.
So he sends an email or text message to the state's attorney saying, "I really want to resolve this. My client's in the hospital. If we can't, we're going to meet with that person." And he can point to an order that a reasonable person can say shows that there's no prohibition of doing that. How could a fact finder or anybody conclude that he knowingly violated an order that at that particular point in time reasonable people can disagree on?
So I'll start with the respondents telling the assistant state's attorneys that he was going to arrange this meeting, and I think that was resolved by the hearing judge in the finding that the respondent was a zealous advocate, that there was an absence of a dishonest or selfish motive because the respondent was so overly zealous in representing his client, it didn't matter that he was going to violate a court order. He believed in Miss Lemon's innocence. He believed that she was not guilty and was willing to violate a court order in order to prove that.
But what about the findings that specifically talk about Judge Crooks lamenting the fact that Mr. Weinberg was taking a literal reading of the home detention order, and he decided to eliminate any confusion? How should we square Judge Crooks' own assessment of the record at that point with Mr. Weinberg having knowledge that he was committing a criminal act?
Again, I think it goes back to Judge Dumais' credibility determinations, where she saw this evidence, she read the transcript where Judge Crooks says that. She heard the respondent's explanations that in succession they were different each time, and she resolved that credibility determination and found that the respondent knew about the no contact order. So whether the hearing judge was certainly entitled not to believe his statement that he didn't know it was in effect. But how does disbelieving that statement translate into affirmative proof that he did believe it? Because I think that would be an extension of, we'd be going out on, I think there's case law that says not believing a denial doesn't constitute proof of the affirmative. So Judge Dumais found that the no contact order was in place. She reviewed the evidence. She reviewed Judge Crooks's explanation on the record. She reviewed that transcript and found that the no contact order was in place.
But she really didn't provide any reason. She just said, I disagree, and the no contact order was in place. She didn't provide any case law or any real analysis for that. So on the legal question, which I think this really comes down to, even though there are questions about what he knew, I think it comes down to the legal question of whether that order was in place or not.
And I think that the assistant state's attorney that was called was able to testify that in cases like this, there are those provisions that are put into place, those no contact orders, and the assistant state's attorney testified that the no contact order was in place.
But why didn't the state's attorney, I think it was Mr.
Neubauer,
why didn't he text him back and say, don't you dare? How dare you threaten to violate a court order?
I did not ask that question.
It seems like that would be a reasonable thing for a prosecutor to do under that circumstance.
That's not part of the record, so I can't speak to why Mr. Neubauer did or did not respond.
Well, can we infer from the lack of a response that at that point in time the prosecutor didn't perceive there to be a violation of a court order?
No, I don't think so, because you have to look at the totality of the respondent's communications to the prosecutor's office, in which he was making these outrageous settlement demands that the state was going to pay his client $100,000 because they falsely prosecuted this case. They were going to drop it immediately. The respondent reached out to Mr. Neubauer's supervisor, the deputy state's attorney. So we think you have to look at the totality of the respondent's conduct and his communications with that office, and that can help to formulate an opinion as to why they didn't respond and they weren't responding to Mr. Weinberg.
I'm going to go back to the 8.2 violations, and I'm kind of parsing out the various communications. You said that all of this is basically false statements and not opinions. And if we do apply the subjective test that the court applied in Stanalonis, looking at the flyer, when Mr. Weinberg says the court refused to apply the law on multiple occasions, ignored the law and rules, how are those false statements of fact on this record, given Mr. Weinberg's subjective beliefs at the time about the Sixth Amendment violation and what happened to his client? How is that not opinion?
So like Frost, I think that this court needs to take the statements as a total in sum. And it's certainly can be that if one statement is made in a larger flyer or a larger explanation, that certainly maybe one statement may not constitute a violation of Rule 8.2a, but the statements in total on the flyer constitute the violation.
So can you tell me what's a false statement on the flyer? What's not opinion on that flyer?
None of it is opinion on the flyer. Judge Dumais found that they were all statements of fact.
So Judge Dumais found that Judge Albin's refusal to apply the law on multiple occasions was a false statement of fact.
Correct. And you have to take the statements as a whole, right? It certainly can be that one statement, like in Frost, that a judge is lawless, may not constitute a violation of Rule 8.2a, but it's the statements taken together in conjunction.
So again, going back to the flyer, are we bound by what Judge Dumais thinks as a matter of law is a question of fact or law on that flyer? Are we bound? I understand that we defer to Judge Dumais on credibility determinations. I'm asking you whether we apply a similar deference when we're analyzing an 8.2 violation with some First Amendment overlay.
Yes, I think that, so turning to what the flyer says, refused to apply the law on multiple occasions when the law did not fit with the results her or the state's attorney wanted, ignores laws and rules she does not like, deprived innocent woman of a trial and counsel of her choice, even though the law didn't authorize her to do that. So that taken in conjunction, not looking at the individual statements, those were all statements of fact that Judge Dumais found were made with reckless disregard because there wasn't a substantial basis to back those statements up.
And Judge Dumais, in looking at Mr. Weinberg's subjective intent, didn't attempt to analyze whether there was a violation of the law with what Judge Alvin did when she removed him as counsel.
Judge Dumais found that when the respondent testified that he believed these statements when he wrote them, Judge Dumais found that statement that he believed them, she found that not to be credible.
What's troubling me is that you can have a whole series, an attorney that's subject to the rules of professional conduct should certainly be entitled to criticize the rulings of judges. And I'm having a hard time seeing if somebody's disappointed in a ruling, they walk out and they call their associate, their partner, whatever, and say, boy, I think the judge was really ignoring the evidence and ignoring the case law. That's commentary. I'd be very reluctant to sign on to an opinion that says that lawyers can't do that. Then you bleed it into, then when it's coupled with statements like the judge is a kidnapper, it seems to me what you're trying to do by saying you have to look at it in the totality, you're saying that words or statements of opinion that should not be stifled can get swept into and be deemed statements of fact if you can tether it to something that's factual and false. And shouldn't we be more discerning in what we look at before we issue opinions that could have the consequence of stifling what really should be fair commentary? I mean, none of us in the robes are beyond or should be beyond criticism, even if we disagree with it.
So this court's opinion in Frost looked at the totality of the statements that were made. There were statements made in Frost about judges, about elected state's attorneys, about the attorney general, and they were statements that were made in succession, similar to what we have here. And in Frost, this court determined that you can't parse out one word or one statement from a larger from a larger flyer or an email or a court filing, and that those statements are taken together because it's in conjunction when you read them that shows that the respondent meant them as factual statements.
So why wouldn't it go the other way, too? In other words, just as Gould has pointed out a number of statements in there that I think all the time, that the ruling had no basis in law. There are lots of people who have been saying that about some Supreme Court rulings in national publications, right? People disagree with stuff at a high level and make statements like that a lot. Why wouldn't the fact that those kinds of statements are included in here make somebody conclude that when you put something in there like kidnapping as well, that it's all in the same vein of just throwing out things that you want to say because you're unhappy? Would it go the other way too, when you're looking at the totality of the statements that are made?
I can't answer that. Bar counsel doesn't have a position on those facts. Everything is so fact-specific in attorney grievance matters, and certainly maybe if you had a private claim of defamation, which it's bar counsel's position is not analogous to attorney discipline cases, that certainly may go the opposite way, but every case is so fact-specific that bar counsel don't have a position on whether it would go the opposite way until presented with it.
I mean, I could see a situation where you have a group of statements that individually may not state or be fact that imply some underlying factual basis that you're trying to convey a factual point. But if you're looking, I don't know how to express it I could see a certain group of statements that could convey the impression that the speaker is aware of facts that prove the falsity of those opinions, and you can get into. But I mean, the judge ignored the law. I mean, judge ignores the law, like a judge ignores the law, like how do you prove the falsity? How can you prove the truth or falsity of something like that?
So how Bar Counsel proved that by clear and convincing evidence was to call the respondent to the stand to ask the basis of why he made those statements, to determine whether they were made with reckless disregard as to their truth or falsity, and then when the respondent was unable to provide a basis for those statements, Judge Dumais found that those statements were false. She reviewed the record, she reviewed the transcript, she reviewed Judge Albin's rulings, determined that the respondent's statements had no basis in fact and were false. So to answer your question, it comes down to the hearing judge reviewing the underlying record, and along with, in conjunction with, the respondent's responses to Bar Counsel as to the basis for his statements, and that's how that determination was made.
So if a lawyer perceives that a judge is biased against him and goes before a judge and says, "Judge, I want you to recuse yourself because I think whenever I'm before this court, you do not, you ignore the law." And you're saying that unless that lawyer can get up there and prove factually that the lawyer, that prove to someone else factually that judge ignores the law, that person can be sanctioned under the rules of professional conduct?
No. So if that's the only statement that's made on the record in a motion for recusal, in a prior case, Your Honor, I don't believe that you followed the law or you did not follow the law, and therefore I'd like you to be recused from my case. That statement alone is not what we have here. What we have here is a long-winded statement from the respondent where he calls Judge Albin corrupt, where he calls her a liar, where he says that she stepped into the shoes of state's attorney, where he said that she was complicit in kidnapping. And so, again, as in Frost, we have to look at the totality of that circumstance and to show that the respondent meant those statements to be factual statements.
But to Chief Justice Fader's point earlier, when you combine the kidnapping and the corruption with all the other petitions and grievances Mr. Weinberg had, doesn't it start to sound like hyperbole? In other words, if he said, Judge Albin is corrupt because she took a $5,000 bribe, you can determine whether that's objectively false. But when you say corrupt she refused to apply the law, she denied my client her Sixth Amendment right to choice of counsel, it starts to look like hyperbole, doesn't it?
No, Your Honor, because the statements were made to be factual statements in order to get Judge Albin to recuse herself. And they were made as factual statements in order to convince the public that Judge Albin should be recalled as a judge. They were made as factual statements to attempt to get defense attorneys to believe that Judge Albin is corrupt and complicit in kidnapping. And so when you take it in that instance, it's not tinged with hyperbole, as Mr. Kramer would say. These were statements that were made factually that had no basis and impugned the integrity of not only Judge Albin, but Judge Mulford and Judge Wax.
Ms. Robier, do you want to address the sanction? And the question that I have, I read your recommendation for the indefinite suspension with the right to apply for reinstatement within 1 year or after a year. Speaking hypothetically, if the court were to not find the violations of 1.1, 1.2 for violation of the no contact order and the 8.2 for the reckless statements, the questions that we've been asking, if we were to find 8.4C and 3.3A1, what would your recommendation be?
The recommendation will not change, Your Honor. From my recommendation for sanction, 3.3 was the overriding rule violation that Bar Counsel determined constituted a violation, constituted a recommendation for an indefinite suspension with a right to reapply in 1 year. And that's based on this court's recent opinion in Sloan and the court's opinions about 3.3, which vary greatly from definite suspensions of 6 months to disbarment cases. And so the violation of 3.3 and the recommendation was made in light of this court's recent departure from Vanderlyn and Collins, where disbarment is not automatically triggered by knowing and intentional misrepresentations. However, because the respondent's misconduct in this case did rise to an egregious and outrageous level, Bar Counsel does believe that an indefinite suspension with the right to reapply in 1 year is appropriate, even though there was arguably no harm to the respondent's client, and in light of the fact that there was no misappropriation. Unless there are further questions, petitioner submits.
Okay, I see no other questions, so thank you, Ms. Robier. And Mr. Kramer, you have the 9 minutes and 40 seconds reserved for rebuttal.
Thank you, Mr. Chief Justice. Before getting to sanctions, I do want to raise a couple of points that Ms. Robier had argued. She talked a lot about the credibility determinations of the lower court. The lower court never really assessed credibility, didn't really look at the record, because that record focuses, in my view, on what took place in a courtroom in derogation of fundamental constitutional rights. One has to understand where Mr. Weinberg was coming from. But rather than take a look at that, the lower court thought this issue was not before the court and made every possible presumption against Mr. Weinberg, including the presumption of falsity and of recklessness. That is indeed, though Judge Dumais thought otherwise, that is indeed the burden that is placed upon Bar Counsel, not upon Mr. Weinberg. The reliance on Frost. In Frost, this court did not have to question whether there was actual malice or falsity. It was already established because the lawyer defaulted on requests for admissions. It was established in the record. There was never a determination of that kind. So Frost is completely inapplicable to this case. The matter was not publicly disseminated. This was kept within the profession. Dysfunctional families though we may be, we're talking amongst the family. Had he published the flyer, I think my arguments on the First Amendment would probably still be the same, but I know that the equities certainly would not be.
When people become lawyers and take the oath, don't they sacrifice or don't they waive certain First Amendment rights that they would otherwise have?
No, they do not. And that's something that we need to understand, that if you're going to pit the First Amendment against the rules of professional conduct, the Constitution wins every time. And I believe that to feel otherwise, that lawyers should only speak out when they have nice things to say, is absolutely antithetical to our Constitution and our government, and to the administration of justice. You want people to criticize. You probably want them to be a bit more civil, and I would agree.
Where in the rules of professional conduct could you interpret as prohibiting lawyers from criticizing judges?
8.2a.
You're not allowed to say anything. You're not allowed to do any criticism of a judge under 8.2a?
Well, it is certainly overbroad in the manner that the Fourth Circuit struck a constitutional or a statutory criminal statute, in that it would punish true speech even if it was done in reckless disregard of truth. Recklessness. 8.2a does not require falsity. Falsity, if you knew it was false, yes, but reckless disregard of truth or falsity, it punishes potentially true speech. Now, I know as applied, you wouldn't do that. You would require that it actually be false. But what we have here really can't be true or false, because I think it really is the realm of opinion. We may disagree on whether the criminal court handled things the right way. But that's something that we as a dysfunctional family are allowed to disagree upon. That's something that we have a First Amendment which guarantees lawyers in Garrison v. Louisiana. The Supreme Court of the United States said, no, you don't forfeit your First Amendment rights. And what also was stated was, judges are not delicate creatures. They need to have thick skin, just as lawyers have to have thick skin. I don't want to condone, and I don't want anything to be taken here as condoning the choice of words. It's not to be condoned. But can it be sanctioned consistent with the First Amendment? I don't think so, and I think in the totality of the circumstances, as Justice Booth observed, you're talking about someone who obviously is conveying he didn't like the judge. But did he hold the profession in disrepute? Not to the public, he didn't. He certainly held particular judges in disrepute, that's true. But he is entitled to do that. This case is different from the cases, if talk about the allegation of intentional misrepresentation to the tribunal. What Mr. Weinberg did was to forecast what the evidence would show. And I agree. He over-argued. I would not have said 100% or absolute or things of that kind. He's trying to get an opportunity, though, to make the case of mistaken identity before the court. He wants to get his lady freed. I'm not saying that's a justification, but at the end of the day, he's got to deliver on that promise. He's got to produce evidence. The court is not simply going to take his allegation of what would be shown and say, oh yeah, okay, she's free to go. No, there's got to be an evidentiary hearing. He's got to deliver that evidence. That's different from Keating, Tanko, and Wemple, where the alleged lack of candor toward the tribunal had legal impact just by virtue of the representation. Signing as a second witness to a will that the attorney didn't witness, for example, would make it legally operative, seemingly.
Did you want to address the sanction?
I do. Whenever we criticize judges, we can be sure of one thing, Your Honor, and that is that the decision on whether to sanction us will be made by another judge. And I think that's one reason why judicial restraint is particularly important here. Bar counsel did not take any exception to the mitigating factors found. My client never before had an outburst like this. He never will again, I'm pretty sure, and so was the judge below. He recognizes that you need to show respect for the court even when judges fail to respect the rights of those before them.
I'm confused. I thought you just told us that they have the First Amendment right to do anything they want, to say anything they want to a judge. So why does he reckon? It sounds to you're saying he recognizes you have to show respect to the court, but you just argued before you actually don't. There's no duty to show respect to the court.
That you should. Not that you have to, but that you should. He's here. I'm here, arguing for his license. Has he learned his lesson as far as that is concerned? Yes. I think the unfortunate lesson is bite my tongue and not speak out when judges do absolutely the wrong thing. That's a sad lesson of this case.
Mr. Kramer?
Yes.
Justice Watts asked bar counsel, and maybe it's appropriate to ask you the same thing along the lines of sanctions. Let's assume that the court overruled your exceptions to 3.3 and 8.4A and C and D. What would your recommended sanction be?
It would be a reprimand, Your Honor, and the reason is that we have an attorney who was motivated by his client's best interests. Actually did a very good job. This is not a case where he wasn't a diligent or competent advocate. He was very much so, perhaps more so than he should have been. We don't want to take away the passion of our defense bar.
Mr. Kramer, let me just tell you, and I don't mean to interrupt you. The motion in which he wrote the 100% positive about Ms. Kirsch's testimony, it was a motion where he was trying to get a probable cause hearing at a point where it's a little unusual. So it looked like he's, I know you're saying overpromising, but trying to get a benefit for his client by giving incorrect information to the court to get this hearing.
I think he was arguing in the motions. And, Your Honor, I believe he had every reason to feel confident that he would be able to prove that and to get unequivocal testimony were she on the stand.
And I don't want to take you off the sanction, but with that thought in mind, that view of the evidence, you still think a reprimand is appropriate?
Well, in Singh, for example, this court didn't want to take a lawyer away from a vulnerable class of underserved clients indefinitely because they knew that it would only be a hardship. If we really want to protect the public, if that's what this is all really about, then taking him away from these people, costing him his livelihood, hurting an understaffed PD's office would be a terrible way to show it.